Good evening, everyone, and welcome to today's discussion. We'll be discussing, after a series of family law, we'll be discussing today a bit of civil litigation, and it is a very important topic today regarding money claims in the UK. And we have got today's expert, Mr. Khandakar Omar Farooq, solicitor and barrister, as well as director of Avista Solicitors, with us. Welcome, Mr. Farooq, to today's session.
Good evening, Joydev. Thank you.
So I know it's a bit topsy-turvy riding for us because we were discussing family laws the last weeks for a couple of weeks, and now we're discussing civil law because we find it very important for our clients as well as viewers. So this is money claim we're talking about, and if I just start with it today, uh, when we talk about money claim, what does it actually mean?
Money claim basically, you owe money, somebody owes you money, and
Hmm.
he's not refusing to pay. It could be um, unpaid invoices, it could be unpaid rent, it could
Hmm.
be a personal loan which is refusing to pay back, it could be unpaid wages, or
Hmm.
it could be money regarding building disputes. So this is a process whereby you ask the court to make an order against the person, and this order is a legal order, and the other person then obviously has to pay. Obviously, there are other steps, but this is the first step. So money claim is like a um, unpaid invoice or unpaid wages, personal loan, and the other person is refusing to pay. So you engage the court, and court makes an order and compels the other person to pay back. So this is, in simple terms, money claim.
Okay, in common sense term, I will say that anything related to money that may be called as a money claim, isn't it?
Yeah, you can say so. Yeah. Mm.
Okay, so when we're talking about money claim, is there anything like smallest amount as a limitation that we are looking for?
Basically, there is no minimum amount you can make a money
Hmm.
claim to the court, but obviously you have to be realistic and practical. Say, for example, if there is an £100 invoice unpaid, and you would think before you go to court, a lot of consideration you will take, like whether it is feasible, engage the court. There's a court fee and time involved and risk.
Hmm.
So, as I said, there is no minimum amount that you can make a claim to the court, but obviously you have to be realistic whether it is cost effective or not.
All right, definitely. So in civil litigation, we have seen different tracks for different types of money claims. For example, there are small tracks, intermediate tracks, fast track, and then multi-track, definitely for the complex cases. We have also seen in the recent trend that there is a pilot project for money claims. So it usually encourages people to do the small money claims by themselves. So if you can just touch in that point as well.
The pilot project started quite some time ago. So how it happens, like the court has trying to streamline this pilot project, and
Mhm.
it has made they had made it very very friendly and easy accessible by the common people and claimant. So I mean, in most cases, you don't need a solicitor, if it is a small claim, and the court process is very straightforward. It's just walk in the park. But obviously, we would always advise to be sure about the strength of your case. Even if you deal with this by yourself, but we will always advise to at least consult a solicitor before you submit a money claim online, especially in the small claim, because even if you um, start the claim online without realizing the strength of the case, because it will be all down to the evidence, you know.
Hmm.
So it's not your word against him word. That will come to later stages, but it's all evidence. So a small claim, um, as I mean, we wouldn't say that you definitely need a solicitor, but again, you can start on your own. But we always recommend that you find out the extent of your case. You know, in
Yes.
that case, yeah. Mm.
Definitely. I mean, in addition to the strength of cases, I would also, I mean, stress upon, the deadlines. I have seen clients, I mean, we together seen clients who have missed the deadline, but probably they did not understand the importance and the code, then pass the order,
Mm.
and then they come to us. So, yeah, deadline is also very important for litigated matters. So that is another thing the litigant in person should take in mind. You have also mentioned that the evidence, I mean, they need to assess the evidence. So when you're talking about evidence, what type of evidence we are looking at?
If I give an example, like if there is a written loan agreement,
Hmm.
and so this will be the vital evidence. Now, we have to see whether this loan agreement is a valid loan agreement, because lots of times what we have seen in the community or in the wider community, like people just draw few lines that I owe you this, and I will pay you back by this date. And in most cases, it doesn't have any witness, or it doesn't even have proper signature, and it may be like not an enforceable contract, you know. So
Hmm.
again, it could be text messages as part of the evidence. It could be email. It could be a witness statement, which is quite useful. Obviously, you have to certify. You have to avert that these statements are true, because if you are found that you lied, then obviously it's going to be a boomerang, you know. So
Hmm.
it's not one thing. I mean, it depends on every case and every on specific facts, what sort of evidence, you know. um,
Yes.
as you can remember, we dealt with one loan agreement, right? And
Hmm.
this person, the defendant, he claimed that the signature on the loan agreement is not his.
Hmm.
Okay, so we had to send his signatures, because we had some unused checks copy and where he put his signature and the signature on the loan agreement to a forensic. Obviously, it cost about thousand or pounds or
Hmm.
so. And at the end, the forensic confirmed that it is 99.9%, 99%. This is his signatures. So
Hmm.
evidence could be a lot of materials, like communication between the parties leading up to the agreement or after the agreement. You know, like unpaid invoice. So the first thing would be like, what was the invoice for, and was there any service provided and paid for, and what was the agreement, and what was the agreement, like how much would be paid, and
Hmm.
how much service was provided. So it's not one thing, you know, it's a lot of
Yes,
things. Mm.
definitely. And we also, I mean, we also need to consider the time limitation. I mean, there is a 6-year time limit within which, I mean, claim needs to be brought up on. And why it is so important, this limitation thing? I mean, we know that clients sometimes find it difficult to understand these limitation points because these are usually procedural defects. So, what would you say to the viewers regarding this? Why it is so important?
This is important because um, you know, if you go to the court has to act with some rules,
Hmm.
and one of the rule is like, um, if you bring, you cannot bring your claim for life, you know. So because then the court will be inundated with litigations and stuff. So
Mhm.
If you can just say like in other Latin, like delay defeat justice. So if you are late, you are denied of justice. This is
Mhm.
unfortunate, but that's the fact. Um, so the 6 year limitation period start normally when the, say for example, the unpaid invoice is due from that 6 years. But generally it is 6 years, but in some cases it could be less. So um, once you have passed this deadline, you have no claim, basically.
Mhm. So yeah,
So
this is
this,
very important, definitely.
yes, yes, absolutely. It's
So,
not only in civil litigation, in other
mhm,
area of civil litigations, limitation is a very important. As you know, that we also in our firm deal with personal injury and clinical negligence, and main
mhm,
factor is that like limitation. It's generally 3 years. So in some cases, you can't get all the evidence and the reports and all the doctors, psychologists, psychiatrists reports within 3 years, but um, it might take longer. So obviously there is a different procedure to be dealt with in that cases. But
mhm, mhm.
we always think limitation, 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 because once limitation is gone, no claim.
All right.
Mhm.
So that is one thing. That is from the claimant's perspective. We have also seen instances where the claim was issued, but the defendant did not appear or did not respond, and the
Yeah.
court issued probably default judgment in those cases. So
Yes,
what's the
yes.
implication for these things?
Okay. Say for example, obviously before the claimant issued the claim, he has to make meaningful communication with the defendant that
Hmm.
this money is owed, and you have to pay by this date, blah blah blah. And after that, because the court always encourage settlement and meaningful correspondence between the parties before they issue claim. So after that, when the other party doesn't bother, then you issue claim. Okay. So once you issue claim, and obviously the defendant will get acknowledgement service and a chance to put defense, but he hasn't bothered to do it. So what will happen? The claimant will have a chance to apply for default judgment. Default judgment means generally there will be any hearing. That means there is a judgment. And now, with that judgment, what the claimant will do? The claimant will engage like bailiff or high court sheriff, or they might put a charge on your property. So
Hmm.
all of a sudden, you wake up one day and say, "Oh, I can see a charge on my property. I was trying to get a remortgage. I was trying to sell my property, but there is a charge. Where did it come from?"
Hmm.
So you got to be very careful.
Yeah, definitely. I mean, these are very, very difficult situation for the defendant. And so, yeah, definitely they need to be careful about the
Never, never, never.
judgments.
I would suggest never ignore court documents. Because
Okay.
it will happen over within short time, and you will know. Then you cannot just come back and say, "Oh, I was away. I didn't realize. I didn't receive the letter." Blah blah blah. So I mean, obviously there are exceptions. Like if you are in a hospital or you are not in a good, you are not in a way that you can
Hmm.
deal with at that moment. Then obviously there is a difference. But obviously then you have to go back to the court and file other application to set aside the judgment. But again, this is costly and time consuming and stressful. Why we bother to go that route?
Yeah. So you have said about cost, so I'll come to this point as well. So I want to touch this one a bit. Legal cost. I mean, when even if it is a small claims of fast track, legal cost is one of the main cost for the claimant as well as defendant. So the usual rule is cost follow the judgment. That is, if someone wins, then the loser pays the cost. Is it the same case in small claims, money
Absolutely.
claims as well?
Normally, it's claim it's a fixed cost, not much, but you are right. The losing party has to pay the winning party's legal cost as well, and so at the end of the day, it might be a big amount. So obviously,
Hmm.
it is how much and when it will be down to the judge. It's a discretion, but obviously, um, again, if you say like you haven't engaged with the claimant before they issue the claim. So the judge might penalize you heavily. And they said like, okay, you have to pay the different claimant's cost, not only on a standard basis, you might have to pay an indemnity basis. Indemnity basis means you might have to pay extra because the claimant has given you opportunity to sort this out before they came to the court, and you didn't bother. So
Hmm.
your behavior are very unreasonable. So it's not only the winning party's cost, and it might be on a very punitive measure, like you have to pay
Yeah.
on an indemnity basis, which is like a punishment.
Yes, definitely. So that is something that's in the hand of the court. So parties usually have little to do in such cases unless they are acting unreasonably. So we always encourage people to do their own work, and especially in a small claims, we advise them to do it by themselves because of this cost situation. Considering that in mind, and based on our discussion today, uh, what advice would you give him to a prospective claimant or defendant in a small money claims?
I already touched this point, but I
Hmm.
would stress again, like personally or in as a solicitor, I wouldn't like to see my client come to me and pay me money, and they probably got like £1,000 claim, and
Hmm.
how much they're gonna pay? It will not be cost effective for us, because if he even if he wins, he will get probably fixed legal cost, probably maybe 100 quid or something. So we always advise um, to do it by themselves, provided he gets or she gets proper legal advice, because
Hmm.
um, there are timelines, as you said, like time limits, and also once the claim is issued, there are steps like you have to do by this date, this, um, and most importantly, if there is no merit, you shouldn't issue the claim. So um, you may be confused or you're not sure. So in that case, we would advise to seek professional legal advice. But when it comes to multi-track or the big value claim, we will never ask the client to deal this claim by themselves, because there will be so many legal jargon and so many stages, so many hearings. They won't be
Hmm.
able to do it. They will rather destroy the case. In that
Yes.
case, they might lose the claim plus pay the other party's cost, where maybe they had a valid case, they had a good case, a strong case. So our advice is always, whether you issue the claim by yourself or not, get the legal advice before you do this. So that would be
So
our advice.
yes, yes. So yes, getting proper legal advice is the key. But viewers, you also need to keep in mind that every case is different, every fact is different. So whenever you go to see a legal professional, they will base their advice on the facts. I mean, there is no model answers, there is no model questions. And the discussion we have today, I mean, it is for general advice only. There is no legal information on, I mean, it's the general procedure we have explained. So if you want any specific advice, definitely we will advise you to see a legal professional. So yes, definitely. If you are also looking for advice on money claims, we you can contact Avista Solicitors or Mr. Khandakaram Farooq in the given number, or you can email them as well. So thank you for being with us today, and uh, Mr. Farooq, if you have if you have got any last words for our viewers.
Last word is, if there is a money claim, whether it's pre-action stage or after the claim was issued, I would urge anyone, don't ignore it.
Hmm.
Don't ignore it. Um, Take it seriously.
All right. So that's a nice advice. Thank you, Mr. Farooq, for joining us today.
Pleasure. Have a good evening and take care. Thank you, everyone.